My name is Brian Audette, and I'm a partner at the law firm of Perkins Coie out of its Chicago office. I've been with Perkins Coie now for just over 12 years, and I focus my practice mainly on corporate bankruptcy and restructuring and also business litigation. I certainly appreciate the opportunity to participate in this year's Boise Startup Week, and I'm hopeful that I can impart some wisdom on the entrepreneurs out there attending this program, many of whom, if not all of whom, are finding these challenging times even more difficult as entrepreneurs. One such challenge I'm here to discuss today is how to address contractual rights and obligations in the wake of COVID-19. I'll be covering three general topics today. First, how force majeure clauses are interpreted and enforced. Second, whether and to what extent a party may be relieved of contractual obligations due to the doctrines of impossibility and frustration. And third, the application of material adverse change clauses in contracts. Generally speaking, contracts allocate risks between two parties. Each party promises to perform some act in exchange for the other party's performance. In that regard, each party assumes the risk that it might not be able to perform in the future, thereby subjecting itself to a breach of contract claim and potential damages. A force majeure clause allocates the risk of loss if performance becomes impossible or impracticable due to a certain specified and/or unforeseen force majeure event that was not caused by a party and could not be prevented by a party. Now, the interpretation of force majeure clauses in contracts are not governed by any statutes, laws, or regulations. Rather, force majeure clauses are issues solely of contract interpretation, which rules of interpretation are governed by applicable state law. Parties in contracts are generally free to choose the state law that they want to govern their contractual relationship, and contracts will usually specify the state law that will apply. So what I'm speaking about today are going to be some more general concepts regarding these doctrines and issues. But in order to know the answer and really pin things down, you'll need to consult the applicable state law that governs your contractual relationship, because while many states are similar in how they address these issues, there may be some different nuances across different states. Regardless of the state law that applies, courts generally construe force majeure clauses narrowly, which means it's difficult to be excused from performance based on a claimed force majeure event. Typically, performance is excused only when the specific event at issue is expressly referenced in the contract. Common examples include acts of war, natural disasters, or work stoppages, things that will prevent a party or make it impossible for a party to perform. However, in addition to those specified occurrences, it's not uncommon for force majeure clauses to include catch-all provisions, but such provisions are generally apply only to events that share the same characteristics as the specified referenced occurrences in the agreement, and the events are unforeseeable at the time of contracting. There's no clear-cut answer on how courts will construe force majeure clauses in the wake of COVID-19 and the global pandemic. However, I think it's fair characterization to say courts will address force majeure clauses as follows. If a force majeure clause includes events such as pandemics or other public health crises, the non-performance relating directly from COVID-19 may be excused because those events were specifically referenced in the contract. If there is no such express reference to those events, but there's a catch-all, non-performance due solely to COVID-19 and the global pandemic may only be excused if, one, COVID-19 has similar characteristics to one or more expressly identified events in the clause, and two, COVID-19 is deemed to be an event that was unforeseeable at the time of contracting. In other words, if the parties could have contemplated it, they should have addressed it in the contract. Now, there are very few decisions that have come down because it's such a new concept here, this world we're living in with COVID-19, as to whether force majeure clauses excuse performance based on COVID-19. However, there is an opinion that has come down from the Bankruptcy Court for the Northern District of Illinois addressing that very issue. The case is In Re Hitz, Hitz, Restaurant Group, and the citation is 616 BR 347, Bankruptcy of Northern District of Illinois, 2020. In that case, a restaurant owner filed bankruptcy. Its landlord subsequently moved to compel timely payment of rent. The tenant, the restaurant owner, hadn't been paying rent because it wasn't generating sufficient income due to COVID-19. And the bankruptcy code specifically requires tenants to timely pay their rent in connection with leases of non-residential real property. In this particular case, the lease did include a force majeure clause, which excused performance so long as performance was hindered by laws, governmental action or inaction, or governmental orders. And in Illinois, after the bankruptcy filing by the restaurant owner, Governor Pritzker issued an executive order that precluded in-person dining, but encouraged takeout and delivery services for restaurants. The court then therefore found that the force majeure clause unquestionably applied, at least in part, because the non-performance was the result of an executive order from the governor of Illinois. However, the court said it would only apply in part because the restaurant owner was still able to operate as far as takeout and delivery services. The restaurant owner had deemed that its income from the takeout and delivery service was only 25% of its general income, and that the in-person dining was 75%. So the court in that case gave the tenant a break and only required payment of 25% rent because the 75% associated with the in-person dining was impossible for the restaurant owner to generate. And the nuance in this case, however, is the restaurant owner wasn't specifically provided the relief based upon solely COVID-19. It was the actual executive order from the governor that actually excused performance, because executive orders, governmental orders, were those items specifically listed in the force majeure clause. So had the force majeure clause not included a reference to governmental action or inaction or governmental orders, this tenant may very well have been continued to be on the hook for the full amount of the rent unless there was some reference to COVID-19 or a global pandemic in the force majeure clause. The second topic I want to cover are two doctrines, the doctrines of impossibility and frustration. So in the event there's no force majeure clause, or the force majeure clause is not applicable, you may be left attempting to rely on the doctrines of impossibility and frustration to be excused from contractual performance. However, you're better off not having to do so, because these are considered by the courts to be extraordinary remedies that are subject to a very high burden. Also, in some jurisdictions, if there is a force majeure clause and it is deemed not to apply, courts won't consider the doctrines of impossibility or frustration. Other courts, however, will if the force majeure clause doesn't apply. So that's definitely something to keep in mind. If there is no force majeure clause, courts generally will allow consideration of the doctrines of impossibility and frustration. Now, let's start with impossibility. As with the force majeure clause interpretation, it's governed by the applicable state law. So you've got to look to your contract to see what state law applies to determine what your rights may be. And the performance of a condition must be rendered impossible by an unanticipated event that could not have been foreseen or guarded against in the contract, okay? So the doctrine of impossibility is not applicable when the impossibility is personal to the non-performing party. It's also not applicable to price fluctuations or market conditions that are typically deemed normal occurrences that are reasonably foreseeable. That said, the doctrine of impossibility does apply when a government action renders performance impossible. So thinking back to the Hitz case that we just discussed, in that case, there was a government action, the executive order from the governor. Okay, so under the doctrine of impossibility, had the lease in the Hitz case not include a force majeure event, the tenant in that case may very well have been able to rely on the doctrine of impossibility because it was the result of a government action. Now, I was able to find an opinion from the Idaho Supreme Court that shed some light on how it construes the doctrine of impossibility. And the case is State v. 2 Ginn, Jinn Incorporated. The citation is 264 P3D 66, Idaho 2011. And the Supreme Court had this to say about the doctrine of impossibility. In order to prove impossibility, 1, a contingency must occur. 2, performance must be impossible, not just more difficult or more expensive. And 3, the non-occurrence of the contingency must be a basic assumption of the agreement. It is the task itself which must be impossible. It is not enough that the particular promisor, that being the party to the contract, is unable to perform the task if it would be impossible for a different promisor to perform. Where the condition is possible at the date of the instrument, that being the date of contracting, and becomes impossible subsequently, the obligation does not become thereby discharged unless the impossibility of performance was the act of God or of the law or of the obligee being the other party to the contract who may have caused the event. So again, here we have a reference to the law. So at least in Idaho, under the doctrine of impossibility, again, going back to the Hitz case, because of the executive order, that was an act of the law. And so a party to a contract that is unable to perform due to an executive order, to the extent one is provided similar to Illinois and Idaho, may be able to be excused from performance based on such executive order. Now, I think it's helpful to go through a factual scenario in a case in order to understand how courts look at these and how parties may address the doctrine of impossibility. And the frequently cited opinion for this doctrine is from a New York Appellate Division case in 1987. And that case is Cal Kim Corporation versus Central Markets Incorporated. The citation is 131 AD 2D 947, New York Appellate Division, 1987. In that case, a roller rink operator defaulted on a lease by failing to maintain adequate insurance coverage as required by the lease, which was the result of an insurance crisis affecting the United States in the mid-1980s. The roller rink operator actually initiated the lawsuit and sought a declaratory judgment that it should be excused from performing its obligations because performance had been impossible, i.e., it couldn't obtain adequate insurance. The court ruled against the roller rink operator. The court stated that impossibility is applied narrowly because, and I quote, the purpose of contract law is to allocate the risks that might affect performance and that performance should be excused only in extreme circumstances. The court therefore concluded that the doctrine did not apply to the roller rink operator because its, quote, inability to procure and maintain requisite coverage could have been foreseen and guarded against when it specifically undertook that obligation in the lease. In other words, that was a foreseeable event that could have occurred and should have been addressed in the contract. That it wasn't left the tenant, roller rink operator, out of luck. And subsequently subject to breach of contract and damages claims, notwithstanding the fact that it could not perform. Now, the doctrine of frustration, while similar, is not on all fours with the doctrine of impossibility. Like impossibility, it's governed by applicable state law. So again, consult your contract, find out what state law applies, okay? And the doctrine of frustration will discharge a duty to perform where an unforeseen event, again, the concept of being unforeseen, has occurred, which destroys the underlying reasons for performing the contract. So different than impossibility, it doesn't state that the contract becomes impossible. However, what it does provide is that the underlying reasons for performing or entering into the contract for the first place have been destroyed. And one court has determined that this doctrine is only applicable if, one, the purpose frustrated must be the primary purpose of the contract. Two, there must be substantial frustration that is so severe not to be regarded within the risks assumed under the contract. And three, the non-occurrence of the frustrating event must have been a basic assumption. Okay? So a high burden to prove frustration like that of impossibility. And I found a case in Idaho from the Idaho Appellate Court which commented on this. And that case is Rasmussen versus Martin, the citation being 659 P2D 155, Idaho Court of Appeals, 1983. The Court of Appeals had this to say. As a general rule, relief from a provision of a contract in order to avoid frustration of the contract's underlying purpose will not be granted where the claimed grounds frustration are merely personal to one of the parties. The frustration must be objective rather than subjective in nature. And another example of a case addressing the doctrine of frustration is out of the Arizona Court of Appeals. And that case is 7200 Scottsdale Road General Partners versus Kuhn, K-U-H-N, Farm Machinery Incorporated. The citation being 909 P2D 408, Arizona Court of Appeals, 1995. In that case, a farm machinery company contracted with a resort to hold an annual dealers convention. Shortly after entering into the contract for the convention, war broke out in Iraq. The company became concerned for the safety of those traveling to the convention, specifically those traveling to the convention from overseas. The company therefore canceled the event and asserted frustration of purpose as its defense when it was sued by the resort owner for breach of contract. Not surprisingly, as with the case we saw with doctrine of impossibility, the court ruled against the company, finding that, one, the company never established that both parties understood that the principal purpose of the contract was a convention for international personnel. It was a North American convention as the way it was titled. So there would have been no reason for the parties to believe this was going to be solely an international personnel convention. Two, the value of the resort's counter-performance, that being the furnishing of its facilities for the convention, was not totally or nearly destroyed by any terrorist threat. And three, the press reports that came out at the time the contract was canceled indicated that the risk to domestic air travel and risk of domestic terrorism was slight. Therefore, the court found no doctrine of frustration applicable in this case. The farm machinery company was therefore sued for breach of contract, presumably either settled the case or had to pay what could have been a substantial sum based on what the size of the convention would have been. The final doctrine or concept that I'm going to talk about is material adverse change clauses in contracts. And contracts may include such clauses that may excuse the delay or termination of contractual obligations due to a material adverse change in circumstances. So again, not necessarily made impossible, not necessarily subject to doctrine of frustration, but there being a material change in the circumstances. Again, governed by applicable state law, so you'll need to check what state law applies to your specific contract. Typically, the material adverse change clause is invoked in mergers and acquisitions contexts. For example, a buyer may be provided the right to terminate an agreement or renegotiate the terms of the agreement if there is a material adverse change that occurs between the signing and the closing of an acquisition. That said, in light of the current climate we're in with the global pandemic and COVID-19, I suspect parties are going to invoke such clauses in the wake of COVID-19 to be excused from performance, or at least renegotiate the terms of their contracts. Again, the party invoking such clause is subject to a very heavy burden. Indeed, this requires the occurrence of an unanticipated event that could not have been foreseen or guarded against in the contract. Notice, nearly identical to the elements of impossibility, that it's unforeseeable, could not have been guarded against. Those are tough things to prove in court. Also, the adverse change must be material, which has been said to be a change that poses a threat to a party's financial condition in a durationally significant manner. So it's got to be a material change, not just any change in circumstances. Something becomes more expensive or products or goods become harder to get. That's not going to cut it. It has to be material. In one court, to give you an idea of how little parties are able to invoke material adverse change clauses to be excused from performance or renegotiate contractual terms, one court in Delaware has stated that a contractual adverse change is like a Delaware tornado, frequently alleged but rarely shown to exist. And with that, I'll bid you farewell and good luck. Thanks again for having me. I'm Brian Audette from Perkins Coie. Thank you very much.